and now no further. And they brought only two categories in that.
You are arguing. What is
One
the...
second, I'm telling
what
the
is-
live issue. So,
No, the question was only whether anything survives.
yes.
that's...
If anything survives,
So, if your lordship allow me to say something here.
we are only of the view, if nothing survives, then there is no point.
But there are individual claims apart from
All
the
of you are
constitutional
all of you
validity.
are adamant that something survives.
There are individual claims apart from the validity. There are applications filed.
Two aspects.
Your
One
lordship
is,
just see the
Let
order
me
dated
on the...
November 2017.
Mr. Sharma,
there are two aspects of the matter. One is questioning the validity of the action. The second is with regard to the implementation of the same and the problem arising. Now, what has been put is with regard to the survival of the validity as such. The second is if there are problems in the implementations where you have expressed that there were problems who could not exchange the amounts, etc. That is a different aspect. So you will have to keep.
If your lordship allow me to say something, my lords, there was an order.
Yeah.
3rd of 11,
I would
2017.
earnestly request Mr. Sharma's matter be detailed. This is the problem on his side and on our side. Both sides are facing. The answer to your lordship's question is, for all practical purposes, it may not survive if, as academic issues, the honorable bench would like to examine that, we are prepared. Otherwise, my lord, it will not survive. That's the answer.
There are individual applications, your
Five
lordship.
judges spend their time for deciding academic issues.
That's all, my lord, I am submitting, my lord. It need not be.
We are already burdened with so much pendency.
So much live matters where rights are involved, my lord.
So, Malad, there were two categories.
May I request your lordship, if your lordship allow me to say something?
Where validity is not questioned.
No.
They were separate initially. The matters in which validity is not questioned, those writ petitions, several orders were passed, and ultimately those writ petitions were said that they will become interveners in this, and their individual grievances will be dealt by the Constitution bench. If that order I have annexed in my IA.
How would the constitutional bench deal with the individual grievances? If there is any reference to that will be answered.
Let me submit.
Yes,
Let me
let me
submit.
The purpose of filing was so that the question because of the mass level exercise which had undertaken at that point in time. So certain important orders were issued by the Honorable Court. And therefore the central government has also implemented, therefore they had allowed the circulation of 500,000 rupees, the denominatized currency for certain reasons. And thereafter with regard to the withdrawal also certain enhancement of limits were also
Please listen to us. Please listen to us. We will fix it on 12th. Please come on that day. But we are going to examine whether it has become academic in nature, whether it requires consideration at all. This will be the first question.
Yes.
Right? Please listen to us. We will hear you on that day. 12th we will fix it. And please come on that day. Let us see how.
Yes, I want to submit one point. Please, Your Lordship, give me a time. Give me a chance.
Come and say on that 12th.
Today itself, Your Lordship, then you can examine all that on 12. That's why I just want to say something. I'm not going to argument anything. Your Lordship, there is 58 petition.
Mr. Sharma, are you appearing as in person?
Yes, Your Lordship.
Look at your,
I'm not bearing the gown.
wearing the band.
Oh, you are saying hurriness before the court. You know the advocate always.
What do you mean
use
by
the-
hurriness?
No, you are saying.
Some decorum has to be maintained.
Just only mistaken. I am removing it. You are now permit me. You say there are 58 petitions. Out of them, 57 petitions are civil nature. One petition in criminal nature. Now you are saying Constitution bench is to resolve the constitutional issue only. They are not sitting for issuing the procedure, policy, all that part. You have to please put this point, if any petition is having challenge to constitutionality of the ordinance, it should be taken up. If some petition are there for the procedure,
List on 12.
oblige you.
You come on 12th, you know. We have not disposed of. Come on 12th. Have you dismissed your application now?
No.
Please come on 12th, let us see on that day.
Very deep of that.
Because interview.
So far as item 502 is concerned,
Yes.
my lord, the contours is the freedom of speech and what are the limitations? My lord, your lordships would recall, I will not take names, but one former honorable chief minister made certain remarks with regard to some, my lord, unfortunate incident of rape having been committed. My lord, according to me, by subsequent judgments, my lord, this law is fairly well settled. But, my lord, we are prepared fully. If your lordships would like to be assisted, what are the contours of freedom of speech?
No, but I saw from the records, the concerned person has apologized and his apologies already accepted. So whether this has also become academic,
Lord,
because he has apologized and apologies accepted here.
Shall I make a very short response to your lordship's query, my lord? I am in I am the next item tagged along with this. My respectful submission to your lordship's query would be this. So this particular case arose from certain statements made by the then minister in Kerala, which were containing disparaging remarks against women, certain employees, laborers, etc., etc. Then the question arose, what is the limit of freedom for the public functionaries? Well, this is an issue which is being repeated again and again. And in fact, in this matter, another bench heard it to some extent, and we even submitted written submissions. That bench cannot be reconstituted because their lordships, respected lordships, got retired. Now, your lordship may have to address certain fundamental issues like limit of freedom to the constitutional functionaries, including the ministers, the MPs, the MLAs, etc., etc. This is a recurring issue happening here or there, very frequently being repeated. Therefore, I would say, it may not be an academic issue. Your lordship may fix a date. We have, in fact, made a thorough research on this as to whether the freedom of a minister is akin to a freedom of an ordinary citizen, and how that will affect the constitutional values, if not constitutional rights. These are the matters which will have to be deliberated. We conducted an extensive research on this. It may not be limited to that UP chief minister's issue alone. Even thereafter, even the central ministers or state government ministers will often repeat this. Therefore, my lord, this is an issue of vital importance. And that is the reason for referring this. And the reason for reference still remains relevant.
I appear as an amicus in the matter, and I agree with the learned SG that these are the matters which have always developed case by case, your lordships. So in this particular case, the issue was fair investigation, and the person has already apologized. And we filed our written submissions, and this is our submission that these issues have already been decided by your lordships in various judgments. The various rights, fundamental rights, they have been balanced into it. So your lordships may take it up and I think we can, should.
So is it the right of only ministers or all other lawmakers? Because whatever statements they make in public, that may have a bearing because ultimately they are the lawmakers.
Correct.
Yes.
Public functionaries, let us
That
not
is
be.
public functionaries, a very broad category, very
Yes.
general category.
No,
Not
even
just ministers.
MLAs and MPs are also public functionaries.
Yes, yes, yes.
So Lordships, this particular aspect is fair
Here
investigation.
incidentally, one of the chief ministers.
Lord, some of the persons, my lord, may or may not be MLA or MP, but still as a leader, he may be in the capacity of a public figure,
There we may not be.
a party president or something. But the
is-
point is this, my lord, whether Article 19(1)(a) and the exception thereto would be differently applied to public functionaries while they are speaking to a larger audience or not. That is the question, which is a live question. Thereafter, my lord, after framing of this question, this is a matter of 2016. The contours are, my lord, defined, as the learned amicus rightly says, on case-to-case basis. And it would essentially be, my lord, it would not be possible for your lordships to lay down straitjacket line of distinction that you can cross this line and not this line. It would be an individual case where law will have to be invoked. Somebody makes a statement which is, Lord, not strictly in accordance with 19(1)(a), but transgressing his right, freedom of speech. But the question is important, my lord. My learned friend, my lord, has.
Your colleague has done an exhaustive research.
Yes, my lord, we have done the research.
So far as,
See,
Available in public domain.
see, right to freedom of speech and expression is essentially against the state. And 19(2) are the reasonable restrictions. Now, if a particular person has made a speech which is not liked by somebody else, then that somebody else can always take action. Now, when 19(2) is already there and 19(1)(a) is there can't be some other restrictions over and above 19(2) which can be imposed because the Constitution doesn't recognize that. Therefore, the question is, if anybody is aggrieved by somebody's speech, what action can be taken?
Your ladyship, my lord, your ladyship is absolutely right. My lord, in fact, our written submission is in this line, or may not be in, because of 19(2), a further restriction, that to a judicial restriction, may be apparently impermissible. But at the same time, when there are horizontal right violation, what else could be done? In fact, my lord, in our written submissions, we have made a suggestion how a constitutional restriction can be made without hampering the constitutional values. This is the purpose. We have suggested what a kind of promulgation of self-regulation for public functionaries, borrowing, my lord, certain models from other jurisdictions. We have placed it right from England and from Australia, how the public functionary should behave publicly. That is very important. For example, but in the Kerala minister's case,
This is one aspect, please listen to us, but it requires a factual background, right?
that's right.
You can't decide a question in thin air. You need certain facts. On the basis of the facts only you have to decide.
Each one.
Now, we don't know what the facts are here. Can you lay some general guidelines, without factual background?
so far as Kerala case is
I may
concerned,
answer that. In fact, as far as Kerala case is concerned,
Okay.
this arises
So
from
far
a
as
matter
UP case is
from
concerned.
Kerala High Court.
Just 1 second. What is that?
so far as UP case is concerned, my lord, there has been an investigation. Subsequently, the chief minister opposed. So far as Kerala case is concerned, once when he was the minister, he made a remarks like this. Then we moved the High Court. High Court said nothing doing. Thereafter, we were granted liberty to come here, and we were granted liberty to get impleaded here.
Who are you? Who are you?
I am for an intervener in Kaushal Kishore's matter. Therefore, that fact remains. Thereafter, what happened is he still goes on making such kind of remarks. Therefore, my lord, this has to happen. So, at least so far as Kerala case is concerned, there has not been an investigation. No investigation happened. No report came.
Does he?
No apologies.
Please listen.
Yes.
Does he deny that allegations made, or does he admit and he says
He admitted, and thereafter.
he asserts it?
Yes,
He has
he
a right.
asserts it.
He
And
admitted that
one
he-
such one of his remarks ultimately resulted in some other case being
re-investigated, further investigated and a final report being preferred. He made a submission.
The facts,
This case on 12th November.
12th, yes,
We have hardly 2 weeks.
Yes.
we have placed.
I must say, my lord, as an officer of the court,
Facts
that
will be
told,
discernible.
only a minute.
1 second. Facts will be discernible from the memorandum itself, my lord. It is stated from
Yes,
page
sir.
F to K.
1 minute, Mr. Counsel, please,
We
1
will have
minute.
it. Oh, no, we can have it only.
Saturday.
No, 15 November.
I'm sorry.
November.
Grateful.
List it on 15th, right?
Yes, my lord, I must say, my lord, the threshold of my right as a freedom of expression, speech and expression, if I am in a public leader capacity, would be much higher. There is no doubt about it. A layman can say whatever he wants, and a leader may still not be able to say whatever he wants. But to judicially define that demarcating line would not be, my lord, a
It will be
easy
difficult.
exercise.
And it has always to be related to the factual situation.
Factual situation. It will have to be subject to
Actual situation, my lord, in Kerala case, my lord, has been indicated right in the judgment and even in the SLP, my lord, 3 instances. And after the instances, not only that he didn't deny it, he even reiterated it, he even justified it. My lord, that is a big problem. And similar situations occur elsewhere also. Therefore, this requires a deliberation.
Worships, in this particular case, the issue is fair investigation and balancing the right under Article 21, which is a fair investigation, and right to speech. So, Your Lordships, this issue has already been decided. We'll show it to Your Lordships, and Your Lordships will then examine it and lay the guide.
We will have it on 15th,
Yes.
right?
Yes.
List on 15th.
Yes. My lord, may I make one submission? 107414, I am the intervener. My lord, may ask, my name is not being shown, therefore I will have.
Show his name also.
Yes.
bribe to vote in a particular manner in Rajya Sabha election. Earlier, there is a judgment, my lord, in case of P. Narasimha Rao, where, my lord, the court took the
I thought it is covered by.
It is covered, my lord, but the
Covered.
court said
It is how many judges?
Please to do 5 judges.
5 judges.
5 judges.
majority, my
I
lord,
thought it covers, squarely covers Narasimha Rao's case.
yes, my lord, the court, my lord, while referring says this, the majority view, while acutely conscious of the seriousness of the offence, felt that the wrongful act and, within brackets, sense of indignation of the bench should not lead to a narrow construction of the constitutional provisions which may have the effect of impairing the guarantee to effective parliamentary participation. So, maximum leverage to be given, or the right of privilege should be read in its broadest possible term. That was the 3 honorable judges' view out of 5. Thereafter, my lord, the reference says, having considered the matter, we are of the view that having regard to the wide ramification of the question that has arisen, the doubts have raised, and the issue being a matter of substantial public importance, we should be requesting for a reference of the matter to a larger bench, as may be considered appropriate, to hear and decide the issue arising. we order accordingly. Otherwise, the
Rarely covers. And this judgment in even courtroom exchanges also, it applies.
yes, my lord. Yeah, though our privileges are, my lord, much lower threshold, my lord, but
Yes, it
they are not, my lord, the legislators, whether in parliament or legislature, they are not even amenable to contempt jurisdiction. But that's not the question here. Its question is of a criminal offense.
So if your lordship would consider, your lordship would
Or only the question is whether it is the only the act within the house or the entire scope of the act has to be
Well,
considered.
see, here the leadership is absolute.
Immunity has to be given to the entire act
yes.
or only to what happens on the floor of the house.
I commit an offense outside and the result is in the
Yes.
within the house. That is one. So one issue. I am not raising this question, but I am flagging it for your lordship's consideration. So as my lords have rightly said, this is as such covered by P. Narasimha Rao, which is a 5-judge bench judgment. And the court felt that considering the seriousness, this needs revisiting. So whether that revisiting would be permissible or possible or at least effective in this combination. Because 5-judge view, my lord, your lordships may perhaps, my lord, feel bound by. Though it is 3-2, but now in view of the recent
judgment, you can't
recent
raise
judgment,
that
my lord, that
You can't know the
numerical
numbers,
it can't go by the numerical strength.
It's a judgment of the bench.
It is a bench, yes, the judgment of the bench.
Let us see on
Great, please.
15. Even 9.
This is an issue, my lord, which your lordship will have to examine. Hardeep Singh's judgment is already there. According to me, my case is covered by Hardeep's.
This needs, but this is interpretation of section 319 of the Code of Criminal Procedure.
The other
This is my
side,
question.
the other side said that it has to be interpreted. And I said that 2-judge bench.
At what stage you can invoke 319? That is the
Correct,
question.
That's the question.
When the judgment is reserved, when the case is reserved for judgment, can we invoke thereafter?
Yes.
That is the only point.
One and the last issue which the honorable bench referred was, what are the ingredients to be taken into consideration? Hardeep Singh goes on that also. Even that is answered. Dispute that, the attorney and the solicitor, or even the additional solicitor. But allowing that application, I am opposing.
Why?
The reason is, this is a case under the NTPS Act. It is a case which is by the Punjab government. The parties to the case are only the Punjab government and the accused, or the complainant can come. The Union of India cannot be a party. Your lordship may let that application be, my lord, your lordship, without allowing it. They can address if they want. I cannot stop even otherwise the learned solicitor from addressing. But if your lordship wants to make an order, then please issue a notice. I'll file my reply and your lordship may take a view.
But the limited point is this, my lord. When your lordships
Reason is, the real reason is, on the basis of this, they have started PMLA proceedings against you. Now, in those PMLA proceedings, they are using the same allegations. So this is a roundabout way of protecting their PMLA proceedings. They have said so in the application also. So this is not an application that somebody wants to genuinely come and help your lordships in interpreting the provisions of law. This is a interest in this litigation. And that interest in this litigation is irrelevant in my respectful submission for the purpose of this matter before your lordships.
But one thing is certain, on account of the pendency of this case, there may be large number of cases pending in the
not only
Yes.
I'll just respond in 2 minutes. your lordships are not examining the facts of this case. So there is no question of my opposing or supporting him. When your lordships are examining a central statute, that is Criminal Procedure Code, the presence of the central government would really be necessary. That's all I am saying.
Your lordship may allow him to intervene without.
It's the matter on 15th now.
Only one more request. No, there is one matter tag 504.4. It's a bail matter. My lord. It may be D-tag. It may go before a regular bail. This 319 question doesn't arise. Of course, we said that it is.
Who's the petitioner?
I am the petitioner.
My client?
No,
The respondent? No.
No, we said that similar
Bail can go before the regular.
504.4 may go before a regular bail. But this 319 question doesn't arise.
Under D-type sanction listed before the.
This is challenging your bail.
All right.
319 is not done.
That is delisted, it will go before the appropriate.
But actually, the High Court has granted me bail. I didn't appear. I was just reading their impediment application yesterday evening. In that, they have mentioned, High Court has granted me bail because the High Court says since this matter is pending, they can't finally decide, take a view. So 504 can let it come on 15 November. Your lordship may take it after this is decided, because then if it goes away, then again I will.
Some date may be given. I am not saying. Some date may be given.
Let it remain tagged on that day when your lordship answers.
You already have been granted bail.
I have.
It is my challenge to the bail.
They are
section.
challenging that.
So let it be considered independently. whether
That's
the-
all, my lord. I'm saying.
Let it go.
Section 319 doesn't.
All right. Next.
Why do you want to, the constitution bench to decide whether the bail is rightly granted
No,
or
no,
not?
I'm only saying it should come after this.
All
After your
right.
lordship.
Wait, next case.
The next case is under the Prevention of Corruption Act.
504.1 also there is a tag matter with these matters. Not just a suggestion, not other
15
benches
no,
in
sorry,
these group
15
matters are
November.
considering not to apply written submission in advance by parties before assisting the court for better assistance. If your lordship was listed on 15 November, any parties to make submissions can circulate those submission in advance, as well as your lordship may consider appointing one of the.
You keep that ready on that day, let us see, right?
Just another suggestion. Look, one of the candidates on record are being considered to be appointed as a nodal officer for purpose of compiling everything and placing before your lordship for your lordship's benefit. That may also be considered.
All right, no. For this case, not necessary. What is?
All right.
See, there is no dispute on facts. The only question is whether 319 can be invoked after judgment is being reserved. That is a legal question. That's all.
That's illegal. Facts are not. And your
Facts are
lordship,
not-
even if they are in
And
dispute,
facts we are not going to examine also.
yeah, even if we raise, your lordship would not examine
We
facts.
will not examine the facts. Next case.
Lord, 505, my lord, is a case under the Prevention of Corruption Act.
Yes.
Here, my lord, the complainant, the bribe giver, died. So there is no question of, my lord, proving the illegal demand being made by him. So whether that can be inferred in the trial, because there is nobody who will prove that. So this may, my lord,
No, that is it the only way to prove, or is there any other way to prove?
that's the question frame, my lord.
The
That's
moment he dies, criminal case goes, is it?
it cannot unless the accused dies. The question.
Accused dies.
There are conflicting views, not so free.
True, we have seen that.
Yes, but that's the question. My lord, very precisely, that's the question. Is it the only way, or there can be other ways of proving?
Bhanumati's odd judgment, of order of reference, we have seen that.
Whether there's an inferential deduction that can be drawn.
On-
Inferential deduction, whether it can be drawn.
On any other evidence which is on record.
That's.
Yes, but inference may perhaps not be a correct expression, because in a criminal trial for punishing someone, you can't do it on inference, but any other mode of proving, that's
Whether a finding can be given with other evidence.
Other evidence on record, no, you can't
Or
infer.
simply
Yes.
the complainant dies, the case has to go.
That's, yeah, that can never.
No, not just the death of
A, B, and C comes and deposes that yes, it was taken in my presence, but the complainant turns hostile. What would be the powers of the court to actually?
whether the demand has been proved or.
Correct.
We will fix it again on 15th, right? We will examine on.
Please.
Item 505.5, my lord.
Hmm.
It needs to be de-tagged because the primary complainant in this case present across the case, cross-examine everything has been happened. And trial court has convicted, but high court has acquitted us. So it has been wrongly tagged, my lord, if it can be de-tagged, my lord.
It will have to wait.
This question has no bearing, is it?
No bearing, my lord. It's IA number 62150, my lord, because primary complainant is there. Entire process, PW11 in this case. So there is no question, non-availability.
Complainant is available, was available.
My lord, cross-examined everything.
Then I think we have to detect, transfer. Give that number. And discuss before the appropriate.
Duryodhan Sahu.
All. That's all?
Please, sir. Grateful to you. 12th of October, rest
These
15th
cases will be on 15th
November.
November.
That is what I
This
said.
is for same date enrollments it should be.
Yes.
The object is supposed to, if any dispute arises with respect to
This again is a little issue.
tiebreaker rules have to be.
No, that's again a issue. Suppose two persons given the application on the same day. One person's application is considered earlier, the other person's application is considered later. Just because of that fortuitous fact,
Yes.
he may go down. And today, when there's
That fortuitous fact always arises, I was telling my brother, and it will always arise.
one way to look at it is, whoever is enrolled within period of say 3 months, their seniority is be determined as per, because most of the enrollments take place sometimes between August and October. Is that maybe because the results are
They do it by.
Now they do it by separation also.
Everywhere.
Earlier we had to wait for.
Madras, they used to sit in the bar council. And there is a kind of a oath kind of a thing also, not for law.
Anyway, this is not subject matter
And
between.
they would have fortnightly sittings.
Similar type of procedure is
This arises from each state bar council having a different fee, a different distinct, all other things are different. Is there a foul in the bar councils to have uniformity? Asking the state bar councils to some uniformity in this process of enrollment.
7L supervision, 7 will not, supervision control. Even will not, this much they can do.
48B
Not uniformity, 15,000 will not in some cases and completely will not it is.
We can issue direction under section 48B also.
It is varying up to, even up to 20,000 enrollment sometimes.
But 48B, 48B may not also, my lords may kindly have a look
Yes,
at.
hardly enrollment, will not is derailment. 20,000.
It's not express for
No,
50,000. It's a large sum of money. So can there be a thought process? Can there be some uniformity in it?
To be.
Some range in it? This is a small capitation fee.
So they permit transfers also.
Yes.
They permit transfer and they assign a capital A, like in my case. We enrolled in Madras, transfer to Delhi. I don't know whether they charge the difference as me, I don't know, but we were given transfers.
That is under section 18 of the act. We have got the power.
48B is a power, I'm looking into this aspect.
And we can look into all these aspects under section 48B
Power to give directions.
or to
You
issue.
have a separate registration for separate senior advocates also, you upgrade or something.
Is section 16.
16.
Provides for separate.
Senior- 16, that is a different chapter, not for senior.
Brother was asking, even there you ask a fee or not?
No, no.
I said, I
Once a person is enrolled, not, we
I
don't
don't
charge.
remember I paid something or not.
So there is a fifth issue to what your lordship mentioned.
Just 1 second.
Right.
You see, very interesting, is section 30. Section 34(1).
Also.
Section 34(1). Mr. Vishwanathan,
Yes, ma'am.
section 34(1).
Yes, ma'am. Laying down the conditions of which an advocate shall be permitted to practice in the High Court.
Report subordinate.
And Article 145 for the Supreme Court.
So High Court can frame a rule saying that you must undergo some kind of examination
145.
before you practice.
Yes, yes. 52 Supreme, reported 145 also the Constitution.
A few years back, my lord, the Patna High Court made a rule that for AOR,
that you will have to appear in the exam, only then you will be entitled to practice there. Sign the Wakaltama and all that.
Subsection 2 of the
Few months back, they have withdrawn it.
Calcutta ki
But
discussion par hoga.
that rule.
Intermediate and final examinations.
No, now it doesn't, because there is nowhere, in no other high court, there is such rule. That is why they had to withdraw it.
No, that rule is there. For example, on the original side of the Bombay High Court, unless you enroll yourself, you can't file Wakalatnama on the original side.
My lord.
You need registration as an advocate on the original side. Perhaps that is referable to this 34(1).
My lord, 34.
The rules provide for it.
Allahabad High Court has also such
Yes.
rules.
Unless you are the role of the High Court, you cannot file your Wakalatnama. They will not be accepted.
My lord, my lord, my lord. That has been upheld by this court.
Yes.
The advocates on record here system under 145(1)(a) challenge upheld.
Okay.
Because there are some you have to have an office within 16-kilometer radius for service, and we are there. So they are the ones who are more directly in touch with the history of the court. The fifth aspect which my lord mentioned flows from the order of in Twinkle. Suppose is enrollment of an advocate, and he suspends it, and he takes up an employee related to law. He's a prosecutor, he's deemed an advocate under CRPC 24. Suppose he becomes a stockbroker. And after my lord 15-20 years, now I'll go back to the bar. There, my lords, Honorable Justice, a suggestion that exam under AH can be insisted because he has been fully unrelated to my lord.
I know more than one case where a person would clear law, that time exams do not exist, enroll himself in the bar, and then suspend the license to take up the job. They used to always say that, our process of enrollment is completed, so that at least we can come back if we don't. That used to happen even then.
But my lord, if he is doing a job allied to law, even a legal officer, group counsel, no problem. But suppose unrelated, suppose he has been in business. Right, straight away entry, my lord has said.
Practically can happen. I don't know how many.
Yes, but your lordship in the other order said, if there is a 5-year hiatus.
That we have any case said in that.
Exam again.
Lord, in Twinkle's case, my lord will remember that we have taken care of that, such persons, that they will have to appear again.
I think anyway they will have to, that rule has to be.
Those are directions passed. You have to structure that also.
No, my lord, the Honorable Justice Pranath drew attention to 49AH. That is not very relevant because there are different categories for which exams may have to be explained. 20 years not related to law. He is coming back and says, now I revoke my suspension of practice, I want to practice. He's holding out to the public as lawyer. Right of audience in the highest court.
Some litigants became lawyers while processing their own cases also.
And some lawyers became prolific litigants.
So these four, my lord, will reflect and have to be permitted to practice in the High Court and the court subordinate thereto.
This rule probably, subject to what Mr. Mishra have to say, will only apply in case you are already enrolled as an advocate. So it will be going by that process, then probably the High Court rules may prevail over the,
Bar council.
because you have to be first enrolled as an advocate, then only you can put the condition. Of course, whether the condition is reasonable or something,
Will be again subject matter of litigation.
that is something separate.
And you know, AH and 34(1) will be harmoniously construed in a way that for that High Court, you'll have to still comply with that. For the rest, you'll have to.
Otherwise, all the high courts where they have framed rules with regard to the right to file vakalatnama and practice will become into an issue.
You raised this issue, Mr. Vishwanathan, because much as I don't like supplementary notes and supplementary notes of synopsis, you'll have to give 1 2-page note. On the issues raised in the court, including some of the issues which I have flagged, issue of interplay. In the discussion, some things have emerged.
Yesterday's issues, there is a 2-page, but these 3 are today's. So, give me a day. Then I was going to give a 2-page on yesterday's. That is ready. My colleagues have ready.
You give us your board days.
Yes,
instead of giving
I'll give
yesterday 2 pages.
I will factor in these 4 also. We had factored in the AH issues.
The AH issue also, if what emerges from today's arguments is will make us all, I think, a little wiser.
Yes.
So, or at least throw up ideas.
Definitely.
So, by the time we conclude, this is a rare case where I would like a 2-page or 3-page note from what emerges from these arguments.
Yes, we will definitely give you lots of.
So, it has different kinds of ramifications for the legal community.
Yes.
Okay.
And just I have made my points.
You're also, who is representing the Bar Council? You will also have to give a short note. Yes, give us pieces.
Not will
Yes.
We also have prepared by indicating that
We don't have multiple short notes. Not possible. You do it, but we'll hear you all. But this can't be that everybody writes a short note. Give it to us. Then we calculate the short notes and combine it. We'll see the second case after we've done 3. We'll see what you have to say.
Very well.
If there is something additional, we'll look. Otherwise, they're not going to look.
That's what I'm saying. No, the rest of the pages
say additional, but whether it is additional or not, let us take a look. Otherwise, the judgment writing itself becomes a cumbersome exercise.
My lord. I'm just going to finish this segment by reading para 78 because the rest has been highlighted, trashed out. I don't have to read paragraphs without that. What 78 alone, my lord, as to how one cannot tag on 49(1) AG with 24 alone. That will be, my lord, the last on this discussion part. This apart, it is humbly submitted, page 35.
Yes.
That the decision of this honorable court in V. Sudhir was not justified in shoehorning the rulemaking power under 49(1) AG of the Act to certain specific provisions of the Act. Firstly, the honorable court held the power under 49(1) AG is only ancillary to the statutory function entrusted to the Bar Council of India under 24(3)(d) of the Act. Finding is based entirely on the fact that both these provisions were introduced by the same amendment of 1964. 24(3) provides that notwithstanding anything contained in 24(1), certain categories of persons could be entitled to be enrolled under the Act, and 24(3)(d) specifically states that a person could be made to be entitled to be enrolled as an advocate under any rule made by the Bar Council of India in this behalf. Further, the said provision states that these persons who are identified are to then follow a specified procedure under the section in order to be enrolled. So clearly, the section which empowers the Bar Council of India to specify certain category of persons to be entitled to be enrolled. 49(1)(g) does refer to the class or category of persons to be entitled to be enrolled as advocates. Over the restricted reading given by this honorable court in Sudhir will not be in line with the scheme and purpose of the Act. Rather, the reading of this provision should be that the rulemaking power under 49(1) AG will be exercised to determine the persons who will be entitled to be enrolled, and this would include the category of persons who either undergo a mandated training or examination. Thereafter, once these provisions are persons are identified, the ministerial act of enrolling such persons subject to conditions that will be specified is carried out under 24(3)(d) of the Act. This harmonious reading of this provision would be in line with the delineated functions under the Act, which relate to the maintenance of roles with regard to State Bar Council and the overarching power to determine those who are entitled to be enrolled. Because Lord Sudhir said 49 is read to be in the context of 24. Lordship may see 24 for a minute. 24 in the action. So that, yes. Subject I have read 24.3 is over the page, my lord. Notwithstanding anything contained in one, a person who has for at least 3 years been a vakil, etc. First December 61 was entitled. Otherwise, these are, my lord, people brought into the advocate side, the pre-61 practitioners. D is entitled to be enrolled as an advocate under any rule made by the Bar Council of India in this behalf. This and classes and category, my lord, can be harmonized. The Sudhir felt that anything in 49, 180 should be, my lord, in furtherance of this D. You could add categories, not prescribe an exam. This is, my lord, may be admitted as an advocate if he makes an application for such enrollment, fulfills the conditions specified in A and H. So, my lord, this is to bring in pre-61 vakils, pleaders, muhtars, before 1st December entitled otherwise than as an advocate to practice the profession of law. C, before the 1st April has been advocates of any high court in any area which comprised Burma, or is entitled to be enrolled as an advocate in any rule. For example, this has to be adjusted with A, B, C, any category left out. Now that we are making a consolidated act of 61, these three plus is entitled to enroll as an advocate under any rule made by the Bar Council of India in this behalf. This certainly has to be, take its color from A, B, and C. This will not detract from, the overarching power under 49.
Just one thing over here. 24E.
Yes.
He fulfills such other conditions as may be specified in the rules made by the Bar Council of India under this chapter.
Yes.
Now, the general power of superintendence is with the Bar Council of India.
Yes,
They can issue also directions to them.
Yes.
Cannot then the Bar Council, taking advantage of this, issue a direction that the before enrollment?
Yes. Yet you will not enroll anybody who has not passed the exam. That is how it has to be read. Not that whatever you.
So, therefore, what can be done is the Bar Council has general power of superintendence.
Yes.
In that exercise of general power of superintendence, then the Bar Council can issue directions saying that that till this condition is satisfied, the State Bar Council will not enroll anybody, and therefore the State Bar Council have the power because they can impose other conditions other than the conditions mentioned in A, B, and A and B.
Yes. That's correct. That is how one has to read it.
But this will be dehorse the arguments which you have already.
Yes, dehorse the argument. Dehorse the argument, and will not.
Sir, that power I have in 48B.
Yes. But Lordship, there will be more than adequate time. The rest of the note, my lord, is there is a segment on post-enrollment. I have already argued at page 37 onwards, page 40 onwards. My lord.
But the only difficulty is with what is the effect of withdrawal of that clause, because then 4D.
That will not affect the 49 1 AG power, my lord. In fact, it brings about uniformity. Just imagine, my lord, the 25 odd bar councils framing their own rules would be chaotic.
Ethics and reasons also. Deletion of clause.
That is
just debating the issue of pre and post. In post examination, as long as they are pre-enrollment is there, they are entitled to take up jobs subject to in law firms. They're entitled to join as law clerks. They get emoluments. We say that a pre-examination, then till they don't clear the examination, cannot be enrolled. There will be again a hiatus period when they do nothing.
No, my lord, law firms take.
My brother rightly put it on one hand, we seem to be concerned by 15 or 20,000 rupees as bar council fee, but on the other hand, people who are by joining firms, by joining lawyers, getting stipends, by joining judges, law clerks are also many all over the country. How does one do it?
No, my lord, the placements happen in college before even their final exam, and they join, and they take their own time to enroll. Depends on how much enthusiasm they show to enroll fast. Otherwise, my lord, the fifth year.
Or the people who are working with lawyers, so people who work with all of you.
Yes.
Is it that the emoluments, you may not be the right examples, but people who join the profession and they start working with somebody, is it that they have to clear the...
No, my lord, those who are able to find officers.
Presumption
All that is required is they have passed the exam and are awaiting enrollment.
Yeah, but all that will happen immediately is that people, as of now, I can take example of law clerks. Somebody graduates law, you take this provisional registration, he is eligible to apply for law. We say a pre-enrollment, will he be eligible to apply for law?
No, your lordship can take it from me. Your lordship may get news items in the law portals about so-and-so university has had 68 placements, 70 placements.
No, those are different.
All that
There's a very minuscule top of the league people who are getting a placement in the corporate side also, in companies or get, so that we're talking about 50 law schools, maybe 50 a little more.
Even in litigation firms, except that since they have to bear the back.
But they constitute only maybe 10% of the law graduates who pass out every year throughout the country.
Even less maybe.
Even less maybe, huh? Let's all go to district courts and different high court and talukas and commissioners court.
Today what happens? The person has to apply, let us take a law clerkship. Any judge here or in the high court. What happens is we say, okay, you get your first enrollment done. So they clear the exam, obtain the certificate, get a preliminary enrollment done, and then they're eligible to work as law clerks. Now, this is one more aspect which cropped up, that suppose it is not so. Suppose there is the exam to be cleared before your enrollment can take place. Then they would be eligible to come as law clerks only thereafter. Unless we even rules that all over the country that you come there. And the problem which will also arise would be that different universities come up at different time with their results. Suppose somebody comes up with the results in September or October, and you are having an exam in October or November. Now, he may or may not be eligible in such a short time to be able to complete the formalities to take that examination. Then goes to March or April.
That they have to hold exams at least
twice a year.
Twice.
You can't ask them to hold it every month. So twice a year they are supposed to hold it. Twice a year they will hold it.
Actually,
I even personally debated in my mind for even enrollment purposes. For example, whether though it's a qualifying examination can be take their marks for enrollment. Because again, another complication as my brother put it. So,
marks with different strata, people come from different backgrounds.
Yeah, so the exam itself is actually an eligibility exam.
Yeah.
As long as they have the cutoff.
Yes.
That should be allowed for.
So that was from enrollment point of view. What is also troubling us is this: if we confine it to
But in fact, the legislative competence of Bar Council of India, as per the Act, that is to be decided. Humble submission before my Lord
we
says.
would like the widest amplitude of power. Of course, certainly.
My Lord, the Act has empowered us.
That's fine. What do you want to do? I'll come to you. What do you want to do ultimately? You want to have a pre, you want to have, which according to you is a better solution. You can't have pre now, post then, pre, post. It can't be vacillating.
No, that we can't do. My Lord, post enrollment is already going on. It's a well-tested formula. And therefore, we are compatible with it. Pre-enrollment, certainly that will not have a separate ramifications. We'll have to study whether we are.
Problem. So I take it your argument is only leave it to us to hold a pre or post after we are putting a post-enrollment examination at the moment. We will continue to hold this. If we have to switch over to pre, we will have to consider all the ramifications. Is that what you are saying?
That's a change in standard.
It is simple submission.
Your lordship's rules only require.
Pre.
You just taken from the website. The candidate must be a law graduate as on the date of appearing at the interview having a bachelor's degree in law. Any school, college, university established in India and recognized by the Bar Council for enrollment as an advocate. This provision is not insisted on the rules from your lordship website for law clerks.
No, but enrollment, eligible for enrollment.
Eligible for enrollment.
How is he eligible for enrollment once he is not taken the examination?
No,
the pre-exam.
Law school has to be recognized for enrollment.
Of course.
That's all they need.
For law class, the last test our norms. You are reading from our norms, right?
Yes, revised scheme for your lordship.
In the revised scheme, you are eligible for enrollment.
No, from a law school, I'll read that again.
Just read it again, please.
The essential qualification, clause 6. 1. The candidate must be a law graduate, bracket as on the date of appearing at interview, bracket close, having a bachelor degree in law, including integrated degree course in law, from any school, college, university, institute established by law in India and recognized by Bar Council of India for enrollment as an advocate. So the institute will should be recognized by them, saying if you pass out from this institute, university,
there is no requirement. There has to be a
provisional enrollment.
Provisional enrollment.
That can also be taken care of by one other way.
Lords have talked of so many engagement in law firms and different fields also. They never accept without enrollment.
On a practical plane, they always say, don't mess with something who's working there. That's another problem. A very, very practical thing. After great effort, has this system been fine-tuned as to post-examination, various things, we pass directions in the other matter, we try to do. So we understand there's a constitutionality to it, which we'll look into, which we'll have to look into it. But
in a given scenario where they want to hold it, and they say, all right, we will not inconvenience students and delay, we will even permit them to appear in the middle of the 5th year. Like many foreign exams are held. You don't have to wait for the last exam. If you have passed 9 semesters in law, always people are dead serious. If they want to do it, they want to do it.
See, we are talking about places where the number of people are how many? Talking about India, where we are talking about 1,500, 1,700 law schools. I don't even know if the whole of Europe has so many law schools. So, this is the system. In everything is a number game. Whether it's courts, whether it's hospitals, the numbers are too large. So, we have to structure things according to the numbers which we are facing. Therefore, is it your say that Sudhir is wrong because it says pre-enrollment cannot be held?
Cannot be held at all.
One.
How they hold it, take care of this, real ground reality.
That's your argument.
That will happen if there is a challenge to the subordinate legislation. And they are told, look, this is the inconvenience we have put. Lordship will
That's different. We don't want unending litigations also on this. We spend time, we want to fine tune it. But Is it also your say that post-enrollment examination need the legislative change? That is what you were seeking to contend.
That is, how it is structured, because it does say act, to place it as it is, because.
Look, if we accept your argument, that 20,
I'm
We
really convinced.
We took it, we'll hear you, don't worry.
if we accept your argument that deletion of subclause D and 28, deletion in 28 is of no consequence as far as powers of the BCI is concerned, then the BCI, in view of the general superintendent's power which they have over the state bar council, they can issue directions to them that please only enroll after you can. Or in terms of 49(1), AG also again, they have the powers that even if you are enrolled as an advocate, your right to practice will be curtailed till you satisfy those conditions. Both the situations.
You were
Not saying other matter.
We actually, the other matter, practical purposes speak to take us ourselves out of, so they need to work it out in a way.
You also made a distinction between right to sit for the exam and right to practice.
Another aspect is, Mr. Vishwanath, another aspect is argument we have also accepted.
So that is a class and category for the advocate.
That's right.
This is one. And the another is one H is to practice.
Yes.
So that is a different category. So for the purpose of the practice, you can put an embargo, whatever it is.
Yes. So, so ultimately, my lord is perhaps suggesting that while classes and categories entitlement, you
So
can
what may be a class and category, they can specify.
They can specify.
For the purpose of.
And they can also specify, having enrolled, how your practice can follow.
Yes.
That interregnum between enrollment and practice, if they say you must clear this, you can clear this.
So that is the, if we see section 6 also, the function of the State Bar Council.
Yes.
We see section 7, function of the Bar Council of India.
Yes.
Then what are the powers to the State Bar Council? 24(1) for qualified to be an advocate.
Yes.
So this is one condition. And for the purpose of advocate, this is a different condition.
So there is another way of looking at it. Now that your lordship mentioned this, there is another way of even looking at it. All that will be required is in AH, since the definition of advocate is only subject to the context of the country.
Only to be enrolled.
Enrolled.
That's all.
So
Now, after that, the right to practice comes.
Correct.
So, AH comes into play there. council.
Argument that the overarching power of the Bar Council of India is not along with this clause. PA seems to give them an overarching. If this overarching power is taken into consideration, then at what stage the Bar Council exam takes place, whether before or after,
It doesn't matter.
doesn't make a difference.
Yes.
Because it means
No, I'm only suggesting one more in that line, which
the lighter side, Mr. Mishra, should we empower you so much or not?
there is one more way of looking at it. In furtherance of it, can you see the definition?
One method is to trust the Bar Council. Let them decide the integrity of whichever way. Our concern is there has to be an exam that we are certain.
Agree on power.
Number two, that exam must be of appropriate level. We are pushing in the other matter.
Yes.
That Justice Naveen Sinha's committee they have appointed are looking into it. Hopefully by next time the exam will be better. Should we embark on the issue of necessarily a pre-enrollment exam and look to all the consequences which may arise in that?
No compulsion at all. Can't be compelled. Only enabling.
Yeah, that's what I think. So, or should we leave it to the Bar Council? In which case they will look to the consequences of either shifting to a pre-exam or post-exam. And we confine ourselves to the constitutional issue in this case. That is the view that only a pre-exam can be held, good or not? If it is so, then only a pre-exam can be held. If it is not so and both are possible, then a pre-exam or a post-exam.
Yes.
Since it affected a large number of bar members, these thought processes have emerged. We are conscious that all of them may not be required for the constitutional interpretation.
There is one more
it
thing.
affects the bar at large. So,
just to take what has fallen, Milord, now Milord, articulated by my Lord, going back on the invalidity of the post bar, if your Lordship sees the definition of advocate and read it with 30, there is a way to reconcile this. Kindly see.
you are referring to section
2A,
2A.
read with 30.
Yes.
Your Lordship sees all definitions are subject to a context unless the context otherwise required. As long as there are clauses where you fit in this definition, in certain clauses your Lordships have freedom to depart based on the context. All that should happen is there should be some clause where the definition applies. It can't be that you just apply the context contrary to every clause. That's the law unless the context is available. Advocate means an advocate entered in any role under the provision of the Act. And 30, if 30 is to be seen as a hurdle, right of advocates to practice, subject to the provision of this Act, every advocate whose name is entered in the state roll shall be entitled as of right to practice, yes, no doubt. Now, AH, condition subject to which an advocate shall have the right to practice.
And the circumstances.
Yes. So, this advocate can also mean who is entered in the provisional role, not necessarily the final role, because he is still not entered in the final role. So, this advocate in AH, tying up with 2A and 30, and the right to impose condition to practice, can also mean, Milord, an advocate who is entered in the provisional role, so that, Milord, they provisionally enroll, and then take out their time to write the exam as prescribed by them. So that, Milord, the 30 problem is also taken.
Another general aspect of this, right? Legislature enacts an act. One looks to the overall arching objective.
Yes.
Is it possible for legislature in these kind of cases to envisage of every mindful possibilities and abilities of lawyers' ingenuity to take into it? There is a overarching role assigned to the bar. If that role is assigned, unless the legislature wants to hedge in the power.
With a prohibition.
With a prohibition.
Which is not.
Any interpretation which gives rise to a continuing role envisaged for them should be permitted.
Incidentally,
Structured,
come back to
structured
Karnam
act.
Panchayats, please.
Structured act.
Okay.
Is
That
that
the whole foundation of delegated legislation and conditional.
giving intent to the removal of the section 34. Vis-a-vis State Bar Council. Even if you look at an objective, it could be justified by saying that every State Bar Council starts prescribing different standards. And the consistency of standards prescribed by the Bar Council of India will be affected. So it is with that objective it was deleted. Is it that they say no, Bar Council will not control the standards of profession? No. Then what are ultimately what is the exam doing? It is controlling the standard of the profession. It is prescribing the standard of the profession. That somebody must, and in a law school where varying degrees of proficiency exist in the law school, you have a common exam to see that people do reach up to at least certain benchmark to be enrolled. Right? So they are luck in the profession. It's not a civil services examination. But you must be able to do justice to your client and assist the court in a reasonable manner.
That's correct.
As much that is why only a benchmark is there.
That's correct.
Should be there. If you look at this, so far in the last years, Bar Council has not done anything by which we should discuss them. I think. So why not give a full
Your
play?
lordships are fine tuning the syllabi.
In any case, we are monitoring those issues in the other matter.
Honorable Sinha is looking into it. Not with.
Yes, meticulous man, he will look into
Lordship says gone to the info model and other things.
It's any judge of this would be have an element of passion to ensure
Yes.
that the assistance rendered to judges. Ultimately, that's the only objective of it. It's not that we want to disqualify somebody, but we should not be left. If he's fumbling, then sometimes we can be left fumbling over issues.
I think that will serve and that's why it's part of administration of justice. We raise it to 77, 78, dealing with establishment of courts, people who practice there. So, I think this, I will rephrase my page 40, para 88 in my second note. Rephrase it in the light of my discussion, rephrase it. So, Your Lordship may, at the moment, give back.
Part of this.
No, my lord. With that, the answers, my lord, 1 and 2, 3 will be rephrased, my lord, saying that there is power. With Sudhir, my lord, of the Indian Council also, Sudhir relied on Indian Council, that age bar of 45, where this honorable court added one line saying that under 49 1AH, you can only mention the people entitled, not those who are debarred. Kindly have a look at Indian Council, because Indian Council was relevant to Sudhir. So both have to go.
Yes.
This it is in the Bar Council's compilation, Mr. Artendu's compilation, page 15. And I'll show where Sudhir relies on it.
Compilation.
Page 15 at 24, and Sudhir relies on this. That is the Attorney General's compilation.
Now you're referring to which one page?
Page 24 of the compilation, a case called Indian Council, where the ceiling of 45 years for enrollment was called into question and struck down.
Yes.
If your lordship will not come to 23 bottom,
yes.
The newly added rule seeks to bar the entry of persons who have completed the age of 45 years on the date of application for enrollment as an advocate for being enrolled as such by the State Bar Council concerned. While section
23 or
sorry, from 24 to 23 for completion
paragraph
of the compilation. Paragraph 8. In the Bar Council's compilation,
yes.
The para beginning, the newly added rule. Bottom.
Yes.
Yes. The newly added rules bar the age of persons who have completed the age of 45 on the date of application for enrollment as an advocate from being enrolled as such by the State Bar Council concerned. While section 24 of the Act prescribes the minimum age for enrollment as 21 years complete, there is no provision in the Act which can be said to prescribe the maximum age for entry into profession. Since the Act is silent on this point, the Bar Council of India was required to resort to the rulemaking power. The rules made by the Bar Council of India under Section 49(1) are in 7 parts, each part having its own chapter. Part 6 is entitled to Rules Governing Advocates, and the said part has 3 chapters. Chapter 1 sets out the restrictions on senior advocation relatable to 16(3) and 49(1)(g). Chapter 2 lays down the standards of professional conduct and etiquette relatable to Section 49(1)(c), read with proviso thereto. And Chapter 3 deals with conditions for right to practice and is stated to be made in excess of powers under Clause AH of subsection 1 of 49. That clause reads as under: conditions subject to which an advocate shall have the right to practice and the circumstance under which a person shall be deemed to practice as an advocate in a court. In the plain language of the said clause, it seems clear to us that under the said provision, the Bar Council can lay down the conditions subject to which an advocate shall have the right to practice. These conditions which the Bar Council of India can lay down are applicable to an advocate, that is, a person who has already been enrolled as an advocate by the State Bar Council concerned. Conditions which can be prescribed must apply to the post-enrollment stage, since they are expected to relate to the right to practice. They can therefore not operate at the pre-enrollment stage. By the impugned rule, the entry of those who have completed 45 years of the date of application for enrollment is sought to be barred. The rule clearly operates at the pre-enrollment stage and cannot therefore receive the shelter of Clause AH of 49(1) of the Act. Under the said clause, conditions applicable to an advocate touching his right to practice can be laid down. And if laid down, he must exercise his right subject to those conditions. But the language of the said clause does not permit laying down of conditions for entry into the profession. We have therefore no hesitation in coming to the conclusion that Clause AH of 49(1) of the Act does not empower the Bar Council of India to frame rules barring persons who have completed 45 years of age from enrollment as an advocate. Impugned rule is therefore ultra vires said provision. Can the rule be saved under any other provision of the Act? As stated earlier, the Act 24(1)(b) provides that the person who seeks enrollment as an advocate must have completed the age of 21 years. Nowhere does the Act provide the maximum age beyond which a person shall not be entitled to enrollment as an advocate, nor does the Act make any specific provision empowering the Bar Council of India to frame such a rule. Reliance is, however, placed in Clause AG of 49(1), which reads as under: AG, the class or category of persons entitled to be enrolled as advocates. Can persons who have completed 40 years of age be said to constitute a class or category to entitle the Bar Council of India to debar them from being enrolled as advocates? Rule 49(1) empowers the Bar Council of India to make rules for discharging its functions under the Act, in particular those enumerated in A to J thereof. None of the functions under the Act, Section 7, specifically provides for laying down such a condition debarring persons of a certain age group from enrollment as advocate. Clause read upon is couched in positive terms, namely it says the rules may prescribe the class or category who may be admitted to the legal profession. Therefore, under this clause, the class or category of persons entitled to be enrolled as advocate may be prescribed. The rule can therefore specify the class or category of persons entitled to be enrolled, but the rule gives no indication that it can debar persons belonging to a certain age group from being enrolled. So it is correlative, it's only the positive part. Once you say only these people can do, the others automatically the others can't do. But kindly see how Sudhi relied on this.
Okay.
So this also will not have to be a larger number. You will kindly see Sudhir in the Learned Attorney General's compilation. Just one paragraph. Learned Attorney General's judgment compilation. Sudhir is here, but already. We will refer here only. Page 50 of the same compilation paragraph.
We mark that. Marks.
So, that is better always. Page 77 in the Learned Attorney General's compilation.
Yeah.
Kindly come to Milord 77, right in column, Precedent F. However, line about 10 from bottom.
Yes.
Yeah. My lord.
Yes.
However, the question is whether Section 49(1)(a)(h) confers such a power on the Bar Council of India. So far as this question is concerned, it has stood answered against the respondent Bar Council by a 3-judge bench judgment of this Honorable Court reported in Indian Council of Legal Aid and Advice. Chief Justice Amely, speaking for the 3-judge bench, to consider in the said decision the question whether the Bar Council of India could frame a rule restricting the enrollment of advocate to the state roll to only those who had not completed 45 years of age. Holding such rule to be ultra-vires the powers of the Bar Council of India under the Act, it was held that such a rule could not be sustained under 49(1)AH as the said provision dealt with the situation after the enrollment and could not take in its sweep any situation prior to the enrollment. The Law Learned Council for the Respondent Bar Council of India tried to salvage the situation by submitting that the said decision was per incurium on the ground that 24(3)D was not noticed. We have already held that 24(3)D is the provision which permits the Bar Council of India by exercise of the rulemaking power to make an otherwise ineligible person eligible for enrollment and does not act in the reverse direction to make an otherwise eligible person ineligible. Once the conclusion is reached, 24(3)D becomes totally irrelevant for deciding the question whether the rule impugned before the three judge in that case could have been sustained by the Bar Council of India by taking resort to 24(3)D. Non-consideration of such irrelevant provision therefore cannot make the ratio of the decision in the opposite case per incurium. Second ground on which so and so, etc. Yes. And again, we note Indian Council mentioned in 79.
10th line from top. Huh?
10th line from top, we note, it is difficult to appreciate how the opposite decision of the Constitutional Bench, we note, and Lily Thomas, for sustaining the rulemaking power, the Bar Council of India, the extra provision of 724(3)D read with 49(AH would be only relevant provisions which were considered by this court in a three-judge bench. Ratio of the Constitutional Bench rendered in connection with an entirely different question posed for decision in the life. So and so scheme dealing with the rulemaking power of the Supreme Court under 145 cannot be said to be laying down anything contrary. So, and then below again at 27, consequently such a rule cannot be sustained, line about 5. Under the opposite provision as clearly ruled by three-judge bench judgment of this court in Indian Council. Even that apart, 49(AH) clearly shows that the provision enables Bar Council to lay down conditions to which an advocate who has already got enrolled can have a right to practice. Right to practice advocate is duly enrolled under the Act is a full-fledged right to practice, which as noted earlier would include not only seeking adjournment but also to plead and argue for the court for whom he appears. Thus, any truncating of very right to practice itself in exercise of rulemaking power under AH by creating a new clause of trainee advocate cannot be sustained by the said provision. All that the said provision enables the Bar Council to do is to frame rules under the said provision which may impose conditions subject to which an enrolled advocate can carry on his full-fledged practice as advocate. In this connection, it is profitable to look at the very rules earlier enacted by the Bar Council of India under 49(AH). They are found in Part 6. Then they go to the training rules. Since Indian Council is relied on in Sudhir in a manner as to restrict the power, considering without the human response to earlier, this part of Indian Council also will not be wrong. Insofar as it will not is to hold that there cannot be a pre-enrollment or a post-enrollment going by that logic. My respectful submission is that the Lordship declares Sudhir Milord as not having laid down the correct law. And Milord, of course, the Lordship will address all the issues, concerns which have now happened, and the fact that the post-enrollment exam is working, which is being fine-tuned in the other matter. So that in the larger interest of administration, Milord, we have mentioned in the in my note, your Lordship will find Satish Kumar Sharma's case that recognizes the overarching power. And so does Milord the Pratap Chandra Mehta's case, the electoral roll case. Milord. I don't want to multiply that. Lordship only flag 84, page 84 of my note, para 84, and Satish Chandra Sharma Milord repeatedly referred to.
Is
in my note, Milord,
yes,
page 33, Satish Chandra Sharma's case on the scope of 49, and Milord, Bar Council's power, page 37, para 84, Pratap Chandra Mehta's case. Milord, the supplementary note, Milord, this 5, 6 aspects will not be addressed. And I'll rephrase para 88. Very grateful for the opportunity.
Thank you. Thank you. This.
Two things will not be section 6 and 7. 6 prescribes will not the functions of the State Bar Council. 7 will not already been discussed not so many times. Now, a lot will see below there are two things. Definition. Section 2. Lord, the Act defines Section 2D Bar Council means Bar Council constituted under this Act. And then E, Bar Council of India means, Lord, so Bar Council and Bar Council of India are two different things. Lord, I'm drawing my Lord's kind attention to these two definition clause. Lord, now coming to Section 415.
Giri, you can come back at 2 o'clock. I think it will take that much of time. Yes. There are 2, 3 other lawyers who want to have a say. I wanted to just mention it to your lordships, but the master may also kindly help me, because the compilation of judgments and compilation of notes and other things, it is in 2 volumes. Not soft copy, I'll send it to the court master. The hard copies also, at least 3 of them, I'll hand it over by one. It was difficult, my lord, because some materials were coming in only late last week. Otherwise, I would have filed the compilation of them. I asked an associate of mine, also an advocate in regard, Mr. Bhagat, my lord, that's fine. Grateful.
So, Lord, Section 15, that is the power of State Bar Council to make rules. Now, this power, if my Lord kindly have a look at. The Bar Council may make rules to carry out the purpose of this chapter. This chapter, in particular and without prejudice to the generality of the foregoing power, and the rules may provide for the election of the members of Bar Council by secret ballot, including so and so. Then the manner of election of chairman, vice chairman, the manner in which and the authority by which the doubts, disputes as to validity, the filing of casual vacancy, power and duties of chairman, constitution of one or more funds, organization of legal aid and advice, the summoning and holding of meeting of Bar Council, the constitution and function of any committee of Bar Council, summoning and holding meeting of the conduct business, qualification and condition of service of the secretary, maintenance of the books of accounts, the appointment of auditors, the management and investment of funds of Bar Council, and then no rules made under this section by State Bar Council shall have effect unless they have been approved by the Bar Council of India. Lord, these are the rule making powers of the State Bar Council. It doesn't talk of Lord the enrollment or all that. Now, Section 49, my Lord has seen, it is just specifically giving power, Lord, to the Bar Council of India. Coming to Section 24, my Lord will see this is the qualification prescribed for being an advocate. This is simply a qualification. I am a graduate, I am qualified to be an IAS. But simply because I am a graduate, I cannot be a collector or an IAS. I'll have to go through the UPSC exam, the preliminary, mains and interview, all that. That is not the condition. The section is very much clear. Subject to the provisions of this Act and the rules made thereunder, a person shall be qualified to be admitted as an advocate. This is simple qualification. How you will be entitled to practice and how you will be enrolled as an advocate, that is the power given to the Bar Council of India under Section 49, under the rule making power. The power of supervision, the power of control, the power to issue directions to all the state bar councils, that is very much already has been discussed, the Section 7 and Section 48B. So, my lord, the power is very much there. My lord, these sections coming to 49 AG, my lord will see, supposing, my lord, a man is law graduate, he has got the LLB degree, but he is an accused, he is charge seated in hundreds of cases. The Bar Council of India can say that such person may be a citizen of India, may be having the law degree, may be fulfilling the other conditions prescribed under section 24 of the Act, but such persons should not be admitted as an advocate. Lord, that is why, Lord, this section AG, 49 AG has been given. And so far, Lord, AH is concerned, my lords are very much, Lord, clear on the point that who will be entitled to practice even after getting enrolled as an advocate. The certificate of practice, that is completely another thing. And that power we get from, Lord, this AH. Lord, that's the simple submission for my lords.
Anybody else from the Bar Council?
Lords, you
Written submission there then.
Lords, the Advocates Act has given power to the Bar Council of India of control over the state bar councils, Lords, in every chapter. As Mr. Mishra has said, because if your lordships have all the chapters, your lordship said in 24 the prescribed condition can be given only by the state bar council. Because even in that chapter, section 28(3), those rules have to be approved by the Bar Council of India. So therefore, my lord, the functions of the Bar Council of India under 7(1)(g), which gives the supervision and control, is an absolute control. It cannot be said every function in every chapter of the state bar councils. If your lordships have the Advocates Act, the second chapter is the bar councils, wherein the functions have been mentioned, lords. Now the functions of the state bar council is section 6. Functions of the Bar Council of India is section 7, my lords. Now in this chapter, my lords, and my lords, as my learned senior has said that the term control in the Nagpur city matter, my lords, that the term control is of a very wide connotation and amplitude and includes a large variety of powers which are incidental and consequential to achieve the power vested in the authority concerned. So if your lordships have section 6, the functions of the state bar council, it is to admit the person as advocates on the roll. My function as Bar Council of India is G, my lords, to exercise general supervision and control. Now this control is with me in every chapter. Chapter 2, section, my lords may see, section 15. No rules made under this section by a state bar council shall have effect unless they have been approved by the Bar Council of India. This is section 15(3), my lords. Then, my lords, just thereafter is chapter 3, admission and enrollment of advocates. Now, my lords, herein, section 24 has given power under 24E to the state bar council to make conditions. Any rule in this chapter, my lords, is at page section 28.
No, just 1 minute.
Yes, my lord.
You see, 24 gives the right of persons to be admitted on the state rolls.
Yes, my lords.
The rolls are state rolls.
Yes, my lords.
Not the central bar council.
Yes, my lords.
Now, thereafter, if you turn to section 28.
Yes, my lords.
Now, the state bar council may make rules for the purpose of this chapter.
Yes, my lords.
So, specific powers for making rules.
Yes.
Is given under 28. We need not refer to section 16 then.
Looks entire chapter.
One minute. We need not refer to chapter 16, section 16 then. With regard to the rule-making power under the other chapter 2. So specific rule-making power as far as chapter 3 is conferred is upon them. You right to that extent that no rules are made under this chapter shall be given effect to unless they have been approved by the Bar Council. But after the rules are made, can the Bar Council of India force them to change the rules?
Milos, under 48B, it is me. 48B1, it is the Bar Council of India, which can prescribe and it shall be complied by the State Bar Council. Milos, may kindly see.
Similar provision is there.
Yes,
whatever reasons, what.
I cannot.
The rule
Once your
15 which
approval
has
is
been
given.
said.
Then therefore they have no right to.
Sub rules
They have
there too. Rule 15 for the purpose of this chapter.
For chapter 2?
Like,
Yes, my
now
lord.
come to chapter 3.
Yes, my lords.
That deals with admission and enrollment of the advocate.
16 onwards, section.
Like,
Yes, my lords.
to which a specific power have been conferred as asked
Yes, my lords.
under section 28
Yes, my lords.
to the state bar.
That to be approved by me under 3?
Yes.
We are not denying of that.
Yes, my lords.
So approval is fine,
Yes, my lords.
but this power is with the state.
My lords.
This is the question.
Now, my lords, here we are talking about the scope and the power of the Bar Council of India vis-a-vis the state bar councils, my lords. Now, what I am trying to demonstrate before your lordships is that the state bar councils, the powers, whatsoever power, the function of the state bar council is to admit on rule. My power is to control the state bar council. So, my lords, controlling the bar council means controlling the functions of the bar council, which ultimately is to admit people on rule. So, my power, that needs to be read with
Writers have to put as.
Yes, ma'am.
Amicus.
Yes, ma'am. Yes, ma'am. Yes, yes, ma'am.
We did in the restrictive manner.
Yes, ma'am. And my lords, for the reason that every chapter.
Difficulty in that argument is when there is a power to make rules given to the state bar council and
Specific power.
specific power,
Yes.
then the principle of exclusion will it not apply?
Because therein, because for example, if I make a rule and I send it to all the state bar council that any person who has cleared an exam after his law graduation shall be allowed or be admitted on the rules, can the state bar council say no? Because I have the power under 48B1 minutes. I can give direction which shall be complied.
Yeah, impact.
Lordship, before dwelling into the written submissions, your Lordships, I'll just refer to one particular rule under chapter 3 which they have made. That is what I'm specifically pointing out is unconstitutional, your Lordship. It is violation of there's a violation of Article 14 in that. Lordship, it is chapter 3, conditions for right to practice. This has been made under rules under 49(1)(h). Lordship, I'm referring to rule number 9 of the Bar Council of India rules.
Have you challenged that rule specifically? Have you challenged the validity of that rule specifically in the prayer clause and your grounds?
Your Lordship, yes, Your Lordship, in my writ petition, which I filed in the, so Your Lordship, this is a 2011 petition when, yes, Your Lordship, I have that done.
Both you've done. Okay.
Lordship, rule number 9, if I may refer.
Yeah.
No advocate enrolled under section 24 of the Advocates Act shall be entitled to practice under chapter 4 of the Advocates Act 1961 unless such advocate successfully passes the All India Bar examination conducted by the Bar Council of India. It is clarified.
Where are you reading?
Lordship, Bar Council of India rules, chapter 3, condition, chapter 3,
Do we have
part
a
6.
copy? Have you annexed it with your compilation?
Your Lordship, this is part of the rules. This.
Our book does not
Our
have.
book is not having it, therefore. we are-
They are in ages compilation.
That is Bar Council of India's rules.
Because they are in
To the rules, not
Bar
to the act.
Council of India rules, Your Lordship.
Because by way how the All India Bar examination
It
is
is there
there
in the.
Your Lordship, in that exceptions we have extracted.
Just, if you were
It is
present
there in
yesterday,
the
page 739, volume 2 of AG's.
Yeah.
Yes, age is notebook.
Your Lordship, in my exception, the first rule which I have extracted.
Where have you extracted it?
Your Lordship, on page number 5 of my written submissions, right after factual background, the relevant Bar Council of India rules inserted for the purpose of conducting All India Bar examination.
What is the page number in AG's compilation?
Is there in his compilation.
Your page 5, you are saying?
Yes, Your Lordship.
1239.
Right at the bottom.
Notice, yeah.
Clearer.
Relevant Bar Council of India rules.
Yes.
May I read, Your Lordship?
Yes.
Rule 9. No advocate enrolled under section 24 of the Advocates Act shall be entitled to practice under chapter 4 of the Advocates Act unless such advocate successfully passes the All India Bar examination conducted by the Bar Council of India. It is clarified that the bar exam shall be mandatory for all law students graduating from the year 2009-10 and enrolled as advocates under the section 24 of the Advocates Act. Lordship, my humble submission here is, let's take an example, Your Lordship, where a person graduates in the year 2007 or 1975.
Yes.
As per Bar Council of India, if that person is getting himself enrolled in 2022, along with a fresh graduate who has just graduated, fresh out of the oven in 2022, the 1975 or 2007 person does not have to give the bar examination. Enrollment on the same date. Application for enrollment on the same date. But it says, because you have graduated in 1975, because you have graduated in 2007, you don't have to give the bar exam.
We could have done that way also. This is the only issue is, at some stage, the introduction of a bar exam was deemed necessary.
I bow down.
Now, that bar exam starts from the whole concept from 2019.
Yes, Your Lordship.
There are sometimes problems which you need to remedy, but you can't do it retrospective. So, especially what is wrong with this?
Your Lordship, if I may say this. Lordship, why it is violative of Article 14? Because
You may be misreading that rule line. Read carefully.
Yes,
It will apply to all fresh enrollments also.
Your Lordship,
It will apply to all fresh enrollments, even irrespective of the year. Plus those who have taken, who had completed the course in 2009-10. So it means that it will also apply to the law students. Just read it. No advocate will be in.
How do you do it? Somebody who has passed in.
Lordship, I have the. Sorry.
Somebody who has passed in 2005.
No, he is not required to.
You don't let.
You're not giving him. He's not required to.
Not required because it was made prospective, not restrictive.
Just read it carefully.
Lordship, in
Just 1 minute. Read it carefully. No advocate shall be enrolled. That is enrolled from the date the rule is enforced.
My lord.
Under section 24 shall be entitled to practice under so and so unless he successfully passes the All India Bar exam conducted by the Bar Council of India.
My lord.
Then comes the clarification portion.
My lord.
Because when was the rule enacted? 30th of April 2010.
My lord.
The clarificatory portion says it is clarified that the bar examination shall be mandatory for all students graduating from so and so year
And onwards.
and onwards. So that means this portion is clarificatory, but as far as enrollment, as far as the main provision is concerned, that will that not stand independent?
What is being put is, suppose somebody has passed the examination, never enrolled with you. He's enrolled, he doesn't have to take the examination. But suppose somebody has passed the examination, did not enroll with you.
No, without enrollment, he can't be. An advocate. He cannot be.
No. I'm saying somebody passed an examination, started doing something else, took up a job, did something else, spent life. And then when ultimately, say at 50 or 55, they say, I want to now enroll. And the period when he's seeking an enrollment is the period of 2013, 14, 15. At say the age of 55. Is he supposed to take an examination or not supposed to?
Lord, as per Lord, my Lord's guideline, we have already made provision for that. But at that time, Lord, the provision was made that those.
Are you taking now? Okay, let me say after the guidelines have been issued, all this.
My Lord, my Lord.
You are taking the examination.
My
So
Lord.
the idea was check and balance even in terms of judgment, which said that somebody may come in at 50. Say somebody may come at 50 years of age, but must take the bar exam. He is not already in it. That is the position.
My Lord.
The charity does.
Your Lordship, if I may just point out, Your Lordship, I have submitted from the Bar Council website, there are frequently asked questions which have been put. Lordship, I'll read out a particular question which is there, which has been put and answered by the Bar Council.
Appreciate in the other orders passed in the other matters.
Yes, Your Lordship.
This issue has been taken care of. So even if you say that they were not reading it in a proper manner, they were permitting people to be enrolled as an advocate who had passed 20 years ago the examination without taking the examination. That issue has now been addressed.
Lordship, there are two places in the Bar Council of India rules. Lordship, there are two rules. One is for conditions for right to practice. Then there's another rule which came in 2015 by Bar Council of India, which is the Bar Council of India Certificate and Place of Practice Verification Rules 2015. There, Your Lordship, definitions, they have clearly given under 4D, Certificate of Practice. Lordship, I'll just read out the Certificate of Practice for convenience. Certificate of Practice in relation to an advocate having obtained graduate degree in law before the academic year 2010, enrolled on the rolls of advocate shall mean a certificate of practice issued under Rule 13 and in relation to an advocate graduating in law in academic year 2009 and 10 and thereafter enrolled on or after 12th day of June 2010. Certificate of practice means a certificate of practice issued under the All India Bar Examination rules or under Rule 13 of these rules or the enrollment certificate issued by the Bar Council.
Is the grievance something else then? Is what I've understood your grievance is that somebody who passed the bar exam earlier, never enrolled himself, is not required to take the bar exam.
Yes, Your Lordship.
While people from 2009 and 10
yes, sir.
have to take it.
Yes, sir.
This is discriminatory.
Yes, Your Lordship.
Therefore, we are telling you, even if it has happened in the past, the manner of construction, fact today is that as per norms today and followed by the Bar Council, anybody who does not, the right accrues only after enrollment. So everybody has to take an exam today, irrespective of when he graduated. As long as his enrollment is after 2019. Mr. Mishra, am I?
My Lord.
Yes, Lordship, as it stands today, the
I'm
rules.
telling you, as it stands is what? You also filed a petition in 2011. See, much water has flowed. Today, the position is it is being made mandatory.
Lordship, the 2015 rules, which was made post that also does not say. And Your Lordship, in this slide, I'll just mention one particular thing, which is because we are going beyond what is stated in letter and spirit here, Your Lordship.
No, spirit is correct.
Yes, sir.
Maybe a little defective, but spirit is correct. Spirit is you cannot get into this profession without taking a bar exam.
As of now, Your Lordship, what I'm submitting is that the rules.
Saying is, please let us be enrolled without taking the bar exam.
No, I'm not saying that, Your Lordship. I'm saying it is violated by Article 14, Your Lordship.
It may be violative of anything. We will not let you enroll as a lawyer without.
I bow down, Your Lordship. I bow down, Your Lordship. Now,
Yes.
yeah, Your Lordship, all I am saying is in this slide, I'll just refer to what Justice Frankfurter said in Mori versus Dowd case. That courts have the power to destruct, not to reconstruct. And I bow down, Your Lordship, that here.
This court has been constructing and deconstructing for a very long time.
No, I understand. I bow down, Your Lordship.
And first part of Rule 9 is so clear. First part of Rule 9.
Yes.
So there's no difficulty at all. That their Article 14 argument is not attractive.
As both my brothers said, this is Khanna also said, that's an explanation. So if they were wrongly construing an explanation, that has been taken care of in the others. See, we are trying to understand what do you want.
No, I am. Your Lordship, I am against the post-enrollment examination and I can demonstrate that, Your Lordship. I am against the post-enrollment. Pre-enrollment might be still valid, Your Lordship, because it is not
valid. Do you want, let me put it a question.
Yes, sir.
Do you want an examination? You think no examination should take?
Examination should be there.
Okay. Now, so far as examination prior to enrollment is concerned, you are okay with that? You feel there is nothing wrong with that?
There is nothing wrong with that, and I have a suggestion with regard to that, Your Lordship. I'll just submit that. Your Lordships were mentioning the large numbers of advocates enrolling every year and all that. Learned Amicus pointed out, I had the same suggestion. Learned Amicus pointed out we can have the examination in the 5th year. Lordship, if I may just submit here, CBSE and ICSE hold examination every year for much more than how many lawyers are getting enrolled every year for 10th and 12th examination. Your Lordship, along with the final semester examination, Your Lordship, I am one of the ones who have given the bar examination and 2010 graduate giving the examination. Your Lordship, that's where I am saying if I would have had the opportunity to give it in the 5th year with all the other examination.
For the bar, we are not prohibiting it. For the bar council to consider. We then they must do so.
Your Lordship, that will stop the wastage of the time of the person who has graduated.
Can be what you are saying is actually a suggestion to the bar council.
Yes, sir.
Council will explore it.
I bow down to Your Lordship. Your Lordship, if I may just point out certain things with regard to the post-enrollment examination, why there is a problem in that particular thing, Your Lordship. Your Lordship, I'll just refer to my particular written submission. They're just giving what were the questions which were raised, which were referred to this Constitution bench, Your Lordship. That was wide and order dated 18 March 2016, Your Lordship. So, Your Lordship, in my humble submission, Your Lordship, that I have annexed as well that particular order.
Seen that order. So, what is?
Your Lordship, the reference is with regard to whether V. Sudhir is correct or not.
Correct.
Your Lordship, whether a pre-enrollment examination can be prescribed by the Bar Council of India. In case questions number 1 and 2 are answered in the negative, whether post-enrollment examination can be validly prescribed by the Bar Council in terms of section 49(1)(h). Your Lordship, my humble submission is their powers get derived from 1(a)(g). Your Lordship, not 1(a)(h) because and if they are doing it under 1(h), Your Lordship,
they have the power, no?
1(a)(g) for pre-enrollment.
Yes.
Not under 1(a)(h), they cannot.
That's the debate, whether 49(1)(a)(g), 49(1), they have the power.
Yes, Your Lordship,
Okay, so that is the source of power is that provision.
Yes, Your
Lordship. You are saying source of power is not A, source of power is another subsection.
Yes,
It doesn't make a difference practically.
Your Lordship, there
the power exists.
Your Lordship, there it has to be in consonance with the other provisions of the Act. Here, Your Lordship, I am completely submitting. When we the functions of the Bar Council is one. I'll just broadly point it out. One is with regard to the legal education per se. The other is with regard to the conduct and how the enrollment function, everything with regard to the advocates. Now I humbly submit, Your Lordship, let's come to the pre-enrollment stage. If we are holding an exam and if we are holding it after my 5th year, after I have got my degree, then Your Lordship, what happens there? Neither am I an advocate, neither I am in the legal education, Your Lordship. I'm not even a part of the legal education because I have passed out of the law school. I've got the degree in my hand. Section 24 enables me to enroll. But
You are saying you are neither here nor there. Enjoy your degree. Nobody stops you. You can do many things. See, how you can do many things. That law degree is a supplement or a benefit for many things. It may be for a job, it may be for people do it even for their own businesses sometimes.
I understand.
Equip themselves. So all those things are open for you.
Yes, sure.
But if you once decide that you will a part of this discussion, then there are certain norms which come into as part of this profession. And to control the quality of people entering into the profession, our council must have a full play, because that's what the intent of the Advocates Act is.
What you are suggesting, the Bar Council will be very happy. If they're given right to hold examinations when you're studying, they'll be the most happy.
Your Lordship,
So at the second and third year of the second and third year law course, and fourth, fifth year in the, or third, fourth, fifth year.
that will be the reason why I'm suggesting that practical solution is only because of this.
They'll be very
We will not be wasting our times after graduation. Your Lordship, I mean, for example, we get a placement offer as well, Your Lordship. We get a pre-placement offer in all the law schools.
Understand what you are saying is, in the final year of your law exams, like you can appear for IIT, you can appear for examination. It is subject to clearance of CBSE.
Exactly.
So the bar exam may be held, and the condition may be then subject to your clearing the examination.
Yes.
Suppose unfortunately you don't pass one paper.
Yes, sir.
Then even if you have passed the bar exam, you cannot get it.
Exactly, Your Lordship.
Suggestion. It's for them to analyze that suggestion.
I am about it. But Your Lordship, I just come to my written submissions with regard to the analysis of section 24, Your Lordship. Your Lordship, and there I have annexed the 1973 deletion, Your Lordship. Your Lordship.
Was that correct or not? That power of deletion was.
That was State Bar Council. I bar for.
We accept that.
Yes.
Now, the intent, if you ask me, would be that the legislature did not want the state bar councils to exercise the power because of a possibility of the system. We don't know, because no rationale is given by it. Maybe it is because of a strike, as you said, maybe because of some agitation. But the taking away legally only takes away the state bar council's power.
Yes,
it doesn't take away Bar Council of India's power. That's not correct.
I bow down, Your Lordship. Your Lordship, I just with that particular thing, Your Lordship, with regard to since 1963, Your Lordship, then in 31st January 1974, then again there was a particular State Bar Council power which was taken away. And that I have annexed with the particular, I have annexed the 1961.
How does it affect the power of the Bar Council of India?
Your Lordship, I am talking about the genesis of the Act per se, Your Lordship. In Act, there were powers given to the Bar Council to do a pre-enrollment examination, or Your Lordship, also.
State Bar Council, again I am saying,
yes, sir.
Powers of State Bar Council are taken away, well taken. Powers of Bar Council of India, has it been taken away anywhere? Please point out.
No, Your Lordship, the Learned Council of Bar Council of India himself pointed out that all the state bar councils do, and then the Bar Council of India runs their functions. So, Your Lordship, in effect, the
power is still. In fact, even though I flagged the issue of, say, the charging being done,
yes, sir.
The purpose was for the Bar Council itself to consider these issues. I flagged it because they were raised, and they are youngest boy.
I have a financial section. I have put a financial section in my particular written submissions, Your Lordship. I'll point out how much we are paying after enrollment. And they say that after enrollment, there's only one fees for enrollment. They charge us 3,500 for everybody for exam. They are earning 42 crores, 44 crores just by holding the bar exam.
Free exam will not take place.
No, definitely, Your Lordship, but 3,500.
Again, can the constitutional court say it should be 3,000, not 3,500?
No, I know.
These are ideas why we read something, though it was not strictly something which we had to analyze. Was the purpose was clearly to flag these issues for Bar Council to examine, which they say so. Now you are saying something else. Certainly there are issues flagged with the Bar Council of India to consider within that domain. That purpose certainly, what you say, into these issues which you have said in terms of where fine-tuning is required. Maybe fine-tuning between Bar Council, State Bar Council of India, all that is required.
I bow to Your Lordship. Then I just turn to section 16, Your Lordship. There are two classes of advocates. Senior and other advocates. Your Lordship, now, when we are having a post-enrollment examination, there's a third category which is being used, which is enrolled, but which is a non-practicing advocate. Now he's enrolled.
It is to facilitate people, that's all. That was made to facilitate, otherwise people would be twiddling their thumb for this long period of time. That has been our concern only. The caveats we have in our mind about the pre-bar exam
Yes.
But as to the consequences of it, please understand. So therefore, when this was given an exam had to be held, they did it to facilitate. In fine-tuning that, in the other matter, we said, okay, keep on with what is happening. Some people are not clearing it in 2 years.
Yes.
They're still continuing. So we passed various orders from time to time in that matter. And we are continuing to monitor it and propose to take it to the logical conclusion to streamline the process. Anything else?
Yeah, Your Lordship, I have just 3 more submissions, Your Lordship. Your Lordship, I can gratefully.